Welcome to this event hosted by the International Association of Assistance Dog Partners. My name is Joan Froling, and I am one of the co-founders and currently the chairperson of IAADP. And today's workshop is titled Access to Hospitals and Other Healthcare Facilities for Disabled Persons with Service Animals. Do hospitals and other medical providers have a legal obligation in the United States to accommodate disabled persons with guide, hearing, and service dogs? And if so, to what extent? We are honored to have with us today two very distinguished guest speakers to educate us on this topic. Sally Conway represents the U.S. Department of Justice, and she is the Deputy Chief of the Disability Rights Section. Eileen Hanrahan is a senior official at the U.S. Department of Health and Human Services, and she is an attorney with their Office of Civil Rights. Before I turn this over to our guest speakers, I would like to talk for a bit about myself and IAADP and our goals in having this workshop. On this next slide, you will see a photo of me and my mobility assistance dog, Spirit. He's a big white Samoyed, which is a sled dog breed with a very gentle temperament. And it's thanks to the many tasks that Spirit can perform, like his predecessors, that I've learned that I can live on my own. I can go many places without having to drag a family member along with me. And I've even been able to travel. And I do recognize that some of the independence that we have here in the United States is due to our wonderful laws that give us access rights. These are laws that permit disabled persons to work outside the home with an assistance dog in many places in the public and private sector. Under the law, these dogs are regarded as medical equipment, although we know they are so much more. Unfortunately, although it sure has gotten a lot better in the last 20 years, there are a number of persons out there who are unfamiliar with these laws, and they may think we're trying to bring a pet into their facility. So we still have a lot of educational work to do, and this workshop is part of that effort. So what is IAADP? We're an independent, nonprofit, cross-disability organization run by disabled volunteers. And IAADP represents and advocates for disabled persons who work with guide, hearing, and service dogs. We held our inaugural meeting in 1993 in conjunction with a conference of Assistance Dogs International and also the Delta Society. And our founders viewed IADP as a self-help organization. We wanted it to empower disabled people with different kinds of assistance dogs to work together on goals to foster the assistance dog movement. And over the years, thousands have done so through our education campaigns, our advocacy work, and our peer support projects. And as some of you know, IADP promotes high training and behavioral standards for assistance dogs and the responsible use of access rights. On this next slide, you'll see a photo of our networking newsletter, Partners Forum. We launched it in 1994 with the intention of fostering a global information sharing and advocacy network. And it currently links together over 350 assistance dog training organizations worldwide, 3,000 IADP members with guide, hearing, and service dogs, and others with a personal or professional interest in the assistance dog movement. And the list next to the photo just enumerates some of our activities over the years, and I'll only touch on a few. We have put on a number of conferences. We've held workshops in different countries. We have an educational website that receives over 250,000 visitors every year, and it facilitates our educational outreach and our advocacy campaigns. And the list also mentions CADO. That is the acronym for the Coalition of Assistance Dog Organizations. IADP was a founding member in 2001, what CATO does is that it enables the umbrella organizations representing nonprofit training programs, such as Assistance Dogs International and the U.S. Council of Dog Guide Schools, and organizations representing disabled persons with guide, hearing, or service dogs to work together whenever an issue comes up, such as new legislation, proposed rulemaking, or something else that could have a serious impact on our community, and it needs a response. And we've learned that by speaking with one voice and showing a united front on a number of issues, it can be very advantageous to our advocacy goals. Our next slide asks how this workshop can assist you. This has been a very murky area of civil rights law. It gets very little publicity compared to fair housing cases and cases involving a denial of access to disabled persons with service animals that want to enter a restaurant, store, or in school districts in the USA. Last year, as editor of Partners Forum, I published a press release from the Office of Civil Rights of the U.S. Department of Health and Human Services. And we learned that a gentleman with a service dog, whom he relied on for balance support, took his father to the hospital for treatment, and the hospital refused him access with his service dog. He subsequently filed a complaint with the U.S. Department of Health and Human Services, and the hospital settled out of court as violating Section 504 of the Rehabilitation Act of 1973. I had to ask myself, why Section 504 rather than the American with Disabilities Act? And it does bring up the question of which law should we cite if we have an access problem in a healthcare facility. So I'm looking forward to learning a lot more about this area of civil rights law, and we also hope this workshop will educate employees of hospitals and other healthcare settings on their rights and responsibilities when they encounter a disabled person with an assistance dog in their facility. And on our last slide, it says, if you have a question about an access problem or some other assistance dog related question, and the website information is insufficient, you can contact our Information and Advocacy Center, which over the years has responded to thousands of inquiries from disabled persons and others about access problems and other assistance dog related topics. Our phone number is 1-888-54-IAADP, or maybe to make it easier for some, it is 1-888-544-2237. Or you can email us at partnersupport@iaadp.org. Now I'm going to turn this workshop over to our guest speakers from the U.S. Department of Health and Human Services and the U.S. Department of Justice. And I would just like to take this opportunity to thank them very much for working with the IAADP to bring us all a better understanding of civil rights of disabled persons with assistance dogs in regard to hospitals and healthcare settings.
Hello, and thank you for joining us. This is the Healthcare Access for Individuals with Disabilities who use service animals. Eileen, Hanrahan, my colleague at the Department of Health and Human Service, and I are really thrilled to be here. And we thank very much Joan for all her work in getting this to actually air, which was not a simple task. What we're going to do today is, this will be pretty brief, and we're going to talk about 3 federal laws that provide protection for folks with disabilities, and in this case, specifically folks with disabilities who use service animals as it relates to healthcare providers. I will talk for a little bit. Eileen will talk later on, and then we have received some really good questions from Joan and from us at IAADP, which we will answer sort of toward the end, and we'll end with a couple of questions. So with all that, we're going to get moving, and I'm going to talk a little bit about who is covered and talk about some legal stuff, but I promise, with the exception of one slide, there will be very little legal language. Okay, so what are the laws that we're going to be talking about here? And we're going to talk about Section 504 of the Rehabilitation Act of 1973. And this applies to anyone, any covered entity that receives federal financial assistance. And it doesn't matter who the organization or company or business that receives the funding. It can be for-profit, not-for-profit, big, small. The key is that they have to have agreed to accept federal funding, and with that comes a responsibility not to discriminate against people with disabilities. And we'll also talk about the Americans with Disabilities Act, and we're primarily going to talk about Title II. And Title II applies to state and local governments, and that's state, county, local, municipal, all kinds of governments that aren't the federal government. And Title III, it applies to things that we call public accommodations, which are actually private entities. They're private businesses, social service agencies, things that offer goods and services to the general public, and that's key. So as you can see from this list, when we ask what healthcare providers are covered, really it's anybody who is providing a healthcare service. And in addition to this list, I just wanted to be real clear that we had gotten a question that dental offices are certainly offices of healthcare providers. And that could be a general dentist, it could be a specialist, it could be an oral surgeon, but we just wanted to make very clear that yes, in fact, dental offices are covered. And what kinds of healthcare activities are covered? First of all, this list is not all-inclusive, but these are representative examples. Pretty much any healthcare provider offers to the public. And it's surgery, it's access to emergency room care, admission and discharge, outpatient services if you have to go to PT or occupational therapy or go in for other testing. All of these things are covered. The other thing that we want to make very clear is that someone who is a companion or a family member of a patient or another member of the public that has a disability, they're covered by this. So it's not just limited to the individual who is receiving that health care at that particular time. And certainly when we talk about access to facilities, we're talking in a hospital context, access to everything that's in the hospital, including, you know, the gift shop, the cafeteria, lobbies, restrooms. So wherever people are allowed to go in a healthcare provider, you should be able to go as a person with a disability with a service animal. Here's the legal stuff that I talked to you about, and this is an actual definition of service animal, and it's really important that you understand this. Right now, a service animal means any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, and that includes folks with physical, sensory, psychiatric, intellectual, or other kinds of mental disabilities. And again, it's a dog. And the last sentence is later on in the definition, but whatever work or task that dog has been trained to perform has got to be directly related to the individual's disability. And that's very important as well. So what does all that legal language really mean? It means that the species that qualify as service animals under federal law here it's limited to dogs. One thing we do want to make very clear is that there are other kinds of federal laws, for example, HUD's Federal Fair Housing Act, the Air Carrier Access Act, that have a much more expansive definition, and they allow they provide access for folks who may use emotional support or comfort animals. So what we're specifically today, we're talking about Section 504 in the Americans with Disabilities Act. It doesn't have any impact on any other law, other federal law or state or local law that provides more expansive definition. And we also wanted to make very clear, particularly that folks with psychiatric or mental disabilities can absolutely benefit from and use service animals. Just because someone says or discloses that they have a psychiatric disability doesn't automatically discount whatever that dog is as just, quote, being an emotional support animal. So we wanted to be very clear about that. So what do we mean when we talk about this do work or perform task? And that really is a term of art. And that's good language for you to learn and to use. And we just say that this dog has to be individually trained to do something on behalf of the person with a disability. And I want to just quickly talk about individually trained. That just means that that dog has been specifically trained to do the work or perform tasks. It doesn't mean that it has to be trained, that animal has to be trained by any kind of an organization that does in fact train service animals for a variety of different things. The ADA, these laws do not require that, but it does require that that dog has actually individually been trained to do this work. And again, the work or task have got to be directly related to the disability. Now, we have given you here an absolutely non-exhaustive list of examples of kinds of work and tasks that service dogs are trained to do. And it could be retrieving items, we all know that, like medicine or telephone, or for someone perhaps like me who has a mobility disability and I use a wheelchair, it may be fetching something out of the refrigerator. It may be doing those kinds of tasks, fetching a straw. And again, the coverage of folks with psychiatric or other mental kinds of disabilities is really, really important. And we give an example here that's fairly broad, but let me give you one example, and that is, again, it's not particularly in the healthcare context, but we see it a lot in education, that kids with autism or who are somewhere on the autism spectrum are benefiting just incredibly, things we never thought about, by using service animals. And one good example of this is if somebody with autism wants to elope or bolting, these animals are trained to recognize when that's happening, and there's a very specific thing that they do and that kid can respond to, and it prevents that elopement. So again, service animals are being trained to do some remarkable work or task for types of disabilities that we never ever anticipated even just a few years ago. Here, I just want to again state that emotional support animals are not covered in the definition of service animals simply because they have not been individually trained to perform a task or do work for someone with a disability. And the innate ability of that dog simply to provide a sense of well-being or emotional support or companionship is terribly useful for that individual, but it doesn't constitute work or task for the purposes of the service animal definition. Now, here's a really big deal, and folks who use service animals need to know what kinds of inquiries can be made and what kinds really can't. And the first thing is that, and this is inquiries made by a covered entity. That is somebody that has obligations not to discriminate under the ADA. So it would be a healthcare provider or a healthcare facility. Generally speaking, if it's really apparent that this individual has a disability and is using a service animal, the best example is someone with a vision disability. I mean, since the 40s, people have understood that folks who may be blind or have low vision have been using guide dogs. So if it's pretty apparent, a covered entity should not be asking any questions. There are only 2 inquiries, and we are very, very clear on this, that can be made by a covered entity. And that can be, 1, is that animal required because of a disability? And they may ask what work or task that animal has been trained to perform. They can't ask, would you demonstrate anything for me? So those inquiries are very limited and very specific. Now, the whole issue of exclusion of service animals has always been a big deal. And as you know, the general rule is that if you're a person with a disability, covered entities have to permit you to come in with your service animal. But we do add, and we have 2 very specific exceptions where a service animal can be excluded. And Eileen is going to talk about this a little bit more later. One is that the animal is out of control and the handler doesn't take effective action to control it. And this really means out of control. And the other is that the animal is not housebroken. And again, Eileen is going to talk about this in more depth, but these are not isolated instances. So those are the 2 times when a service animal can be excluded. And if you notice, we say service animal, not the person. If there's a legitimate reason for exclusion of a service animal, the handler or the individual with a disability really has to be given the opportunity to still come in and participate in whatever the program is or whatever goods and services without the animal. The top says under handler's control, and this is also very important. The service animal has got to be on a harness, a leash, or some other tether. And that's the general rule. The other is that there may be times when either the nature of the individual's disability makes it impossible for him or her to actually handle a leash or a harness, or if the use of that harness, leash, or tether interferes with whatever the work or task is that animal has been trained to perform, then that animal still has to be under that handler's control. And that would be voice control, signals, other effective means that essentially would keep that animal in the close proximity of the individual with a disability, and like it would be were that animal on one of the other kinds of devices. So there are times when perhaps the use of a tether is not possible, but it doesn't lessen the requirement that that individual has to keep that animal under its control. There are other limits, and again, we're talking about policy modifications, and covered entities aren't required to modify policies where this modification would fundamentally alter the nature of the program. And they're also not required to permit an animal if, number one, it runs counter to legitimate safety requirements that all covered entities will have, or if it poses a direct threat to the health and safety of others. And the direct threat is a very specific provision. It's not necessarily included in the service animal provisions, but it is, and always, it is a legal defense. Now, there are some miscellaneous provisions, and everything always comes under miscellaneous, doesn't it? It's the things we didn't know where else they needed to go. So the first is covered entities are not ever they're not responsible for the care or supervision of a service animal. And this means feeding, watering, taking the animal out for restroom breaks, exercise, grooming, any of those things. Those responsibilities always lie with the individual with the disability or the handler. And the second, again, is that service animals may accompany their handlers or people with disabilities to all areas of a public accommodation or public entity. Remember, public entity is state, county, and local governments to which the handler can go. And it's generally, if the general public can go, you with a service animal should be able to go there as well. And you may not see this too much in the healthcare context, but you may in halfway house kinds of things or sort of stepped up intermediate care. If you have a service animal, an entity cannot require you to pay a pet fee or a surcharge. And the reason is that service animals are not pets. So they can't have any surcharges that they wouldn't apply to folks who didn't come in with pets. So, I mean, that's the key thing is if somebody says a surcharge for a pet fee, you just say this isn't a pet, it's a service animal. Now, I have to talk a little bit about miniature horses, and I will talk very little bit. There are some folks in the country who are very effectively using miniature horses. And what I want to do is just give you a quick overview, and I know that this may not be a topic that you folks are dealing with, but it is something that's out there. So miniature horses are not ponies. They're not small horses. They are really miniature horses. And they typically range in weight from 70 to 100 pounds. And they range in height from 24 to 34 inches, right to the bottom of their mane. So as you can see, they're the size of a lot of dogs. And while miniature horses are not considered service animals, we do have specific requirements that reasonable modifications have to be made to permit someone who has a disability to come in with a miniature horse. And again, if you look at that language, it's going to look really, really familiar to you, that has been individually trained to do work or perform tasks. And we provide some assessment factors to help covered entities figure out whether they can allow miniature horses as a reasonable modification of their policies. And they are the type, size, and weight of the horse, and can that animal be accommodated within the features of that facility. This is really a size issue. The handler has sufficient control of the horse. Sound familiar? The horse must be housebroken, and whether the horse is present in a specific facility undermines or compromises legitimate safety requirements. And I believe I'm going to turn this over to my friend Eileen, who will talk to you about really how does this apply in the healthcare context.
Hi everyone, and I just would like to echo the comments and appreciation that Sally Conway, my colleague, expressed for the opportunity to be here today. Service animals are a very important compliance concern for both of our agencies, so we are really glad to have this opportunity to talk about them with you. Now, Sally has given us a good walkthrough of the general standards that apply under the ADA as well as 504 for service animals generally in the very wide diversity of contexts that are covered by the Americans with Disabilities Act. And now I'd like to talk with you a little bit more about how those standards are applied in the healthcare context. As many of you, I'm sure, are familiar with just based on your own experience and almost intuition, some of the issues and challenges that service animals raise in healthcare are very unique and challenging, in large part because of the concern about the risk of transmission of disease or infection to people that may be in the environment. And clearly, we're looking at people who are not necessarily your typical population. We're looking at people that have already compromised health, and some of whom may have very significant health concerns. So the concern that the medical community has about the risk of transmission of infection is a very legitimate one. So we'll talk about how those standards apply. Because this is a healthcare issue, we would like to be able to look to some of the medical science and the background information in the healthcare environment that there is on the risk of transmission of infection from service animals. So we are very lucky to have guidelines that we can turn to, we being lawyers. The Centers for Disease Control and Prevention in the Department of Health and Human Services, where I work, actually issued guidelines back in 2003. These guidelines are still current. We continue to look to them today. They're still good science and good medicine. We're going to walk through a little bit about those guidelines right now. Okay, let me just mention, as you can see, these guidelines were issued in 2003. They are still current, and we will be talking about the standards as they apply today. So in the CDC guidelines, they make a point that there is no evidence that animals pose a more significant health risk to people than do other people. And if you think about your own experience, this seems common sense, that you're more likely to catch a cold or a flu or some virus from some person in your workplace or in your family than you are from your service animal or from some companion animal. In light of this, the principle in the CDC guidelines is that a service animal should not be excluded from an area in a healthcare facility unless the patient's situation or a particular service animal raises some greater risk than would be posed by an animal that cannot be accommodated through reasonable measures. And we'll talk about what those are. You'll remember that Sally said that we're talking about dogs now when we talk about service animals. We used to be talking about other animals where the risk of transmission was higher. So primates, for example, or birds really do pose a greater risk than the evidence is for dogs. And this is an important fact to keep in mind. So the CDC states that if healthcare staff or visitors or patients are able to go into a care area without taking additional precautions to prevent transmission of infection, then a clean, healthy, and well-behaved service animal should be allowed access as well. So I want to focus on additional precautions and the clean, healthy, and well-behaved service animal as we go forward. Well, let me just mention the CDC guidelines were developed in consultation with the Justice Department Civil Rights Division with some of our colleagues back then. And consequently, they were developed consistent with standards that apply under the ADA in Section 504. Of course, those standards have been updated to some extent in the 2010 ADA regulations. For example, the CDC guidelines talk about animals generally, and now we're talking about dogs, but in the important respects, the standards are still consistent and they're still current. And these concepts will be familiar to you from what Sally talked about previously. The service animal should be permitted access with the person with a disability unless the animal's presence or behavior creates either a fundamental alteration in the service or the program or a direct threat to other persons. So here's sort of the bottom line here, the punchline, the gold standard. Excluding a service animal from a particular area is appropriate if the area has restricted access. So by restricted access, we mean the area is maybe one that is subject to certain environmental standards. They may use certain filters to keep the air clean. There may be particular attention to hand washing in the environment, or that there are barrier protective measures required of staff or visitors, such as gowns or masks or gloves. And the reason why it would be permissible to exclude a service animal from an area such as this, and this again seems pretty reasonable, is that the service animal, unlike the person, cannot really make use of these protective measures such as masks, gowns, and gloves. So you can't minimize the risk from an animal in the way that you would be able to from a person. Let me just add a couple of additional principles from the CDC guideline, which will come up a little bit later when we talk about some of the cases that we get. A service animal can't be excluded simply because the healthcare staff feel that they are able to perform the functions of the service animal or because they don't see the need for the service animal. And typically you may see staff saying that they either can push the wheelchair around and take the person to the locations that they need to go, or they can retrieve any of the items that the service animal may be able to do. Again, irrespective of what that function is, that is not a sufficient basis for ever excluding a service animal from an area. And again, care for a service animal, this is in the ADA, Sally talked about earlier, it's in the CDC guidelines as well. The care for the service animal and the control of the service animal is the responsibility of the patient throughout the stay, although the patient can turn to family and friends to help meet that responsibility. So now, we actually want to spend some time talking about the issues and the cases that we have seen in our past few years in enforcement in our agencies. Let us start out by saying that we actually do see a fair amount of cases involving service animals in HHS. I did look through maybe 35 or 40 of them as we were working to develop our presentation. I didn't actually see any involving animals other than dogs, surprisingly, but I know this does come up often for the Justice Department. But I do want to add, in nearly all of these cases, we did identify compliance concerns, either with how a particular person was treated or with the service animal policy that an entity had in place. So it's important to understand what your rights are, because there will frequently be circumstances where you may be facing a policy or certain actions that may not always be consistent with the law. Great, and now we're going to take some time to talk about how the medical standards and the legal standards intersect. And we'll do that by talking about some of the issues that we have seen in our cases. And sometimes I know that DOJ has a very active hotline that gets a lot of service animal questions.
And do not adjust your set. You do see two people.
Oh, thank you. Yeah, so one issue that, of course, is important is who has a right to a service animal. As Sally mentioned, any person with a disability who has a legitimate need to be in the facility, including patients, companions of patients, as well as visitors or members of the public. And I wanted to mention one case where we had a facility that excluded a person because the person on previous visits had never used a service animal, and now they were using a service animal. So I think there was some suspicion that the animal was a pet. But as we know, individuals' needs can change from time to time, as well as a person's interest in using different types of assistance. So just because they didn't need or didn't want to use a service animal before doesn't mean that it is that way today. So we did find that the exclusion was impermissible.
And I'll just add one very quick thing. We're really focusing on this a lot because there just historically has been, if you're not the patient, you don't have any other rights. So it's really important that if you're a companion, you're a visitor, you're there to drive somebody home after an outpatient surgery, as long as you're a person with a disability, you have rights.
Here is a big question. As we know, only dogs are service animals. When we've talked about that, the animal must have been trained. We do see cases involving this issue, and there is a presumption that a person needs to have some evidence of training by an organization or society. As Sally has made clear, animals can be individually trained by either the person with a disability or a spouse or partner or some other individual. Service animals now perform a wide range of functions and tasks. Surprisingly, we still continue to see cases where security staff are blocking individuals' entrance to healthcare facilities, particularly hospitals, where they're asking, is this a guide dog? Is this a seeing eye dog? And our policy only permits guide dogs for the blind. And clearly this is a much more traditional and an older view of the function of a service animal, and it's significantly more expanded than that. So that's important to keep in mind. And another issue that we also see quite often, healthcare providers may not require certification or documentation or tags or jackets. No documentation or certification of any sort can be required. We had one facility that required someone to have a certificate that there was a medical need for the service animal, which is inappropriate for a host of reasons, but in any event, just want to be clear that certification can never be required. And Sally, would you like to add?
No, and I think, and this also goes back to the next bullet point, that there are only very clearly defined questions that are permitted. So again, if you go back to what we talked about earlier, it's, are you a person with a disability that needs this, that uses this animal as a service animal, and they may ask what work or task has the animal been trained to perform, but they cannot ask to demonstrate.
Here is another very big issue that we see in most service animal policies probably, but the principle is, and we've taken the position, that healthcare providers may not require a veterinarian certificate of health or any other health records. And let me just give you some examples of types of requirements that we've seen. We had one covered entity required that the certificate be maintained on file in the hospital for the year. We had another that required an annual physical exam from somebody. We had another entity that wanted to refuse an animal for health reasons, not based necessarily on the animal's condition today, the day of the visit, but because previously they had excluded the animal for reasons of health or apparent uncleanness. So we want to be clear that that is inappropriate. What the entity really should be doing is making a present-day judgment about whether the current status of the animal does pose a significant risk to the health or safety of other persons that cannot be either eliminated or modified or mitigated through modifications of policies or practices. Another issue that we also see are requirements of vaccinations for different kinds of diseases. We had one hospital required vaccinations for distemper, for parvovirus, and for rabies. We actually did a fair amount of research on this and could find almost no evidence of transmission of parvovirus or distemper from dogs to people. And although, as we know, rabies is a transmissible condition, which is why most localities require vaccinations for rabies, looking in the particular jurisdiction where this was located, we actually found about 2 or 3 instances of transmission of rabies, and this was a large city in about the past 10 years. So we really even found the transmission of rabies in this circumstance was quite negligible, but the entity did agree to drop the requirement for the vaccinations as well as its health certificate.
And if I could sort of tack on at the end here, again, it has to be for a legitimate reason. It can't just be like Eileen was talking about in the point above. It can't just be, well, I heard or I read on the internet or experience from 10 years ago. It has to be current objective evidence that is the basis for making a decision to exclude someone with a disability. And remember, you're not just excluding the animal, you're excluding that individual with a disability. So great care has to be taken when these kinds of decisions get made.
And I just wanted to add one point, because I know for many people, it seems logical, it seems reasonable that a hospital or a doctor's office should require a certificate of health for an animal coming into place. The reason why we don't find that it is reasonable is because, as with people, animals' health conditions can change very much from day to day. Just because an animal had a health certificate 6 months ago doesn't mean that the animal is healthy today. Because they may not have been healthy 6 months ago doesn't mean that they're not healthy today. So for one reason, we find that it really is not as much value. It doesn't demonstrate the animal's health as it might appear to be at first glance. And second, because it's viewed as an unwarranted burden on the person with a disability. It means that they have to go to the vet to take the time to spend the money to do that and then basically carry around these pieces of paper with them all the time, even on the possibility that they may have an unanticipated visit to an emergency room. So I think in light of the lack of evidentiary value of the piece of paper to the animal's condition and whether it does actually pose a risk to health or safety of others, it's just not viewed as something that's appropriate to require. Control and behavior, also big issues, and these are general standards that Sally had talked about before that apply just as much in the healthcare context in another. I just wanted to talk about 2 kind of interesting cases that we had, although one seems perhaps the no-brainer. We had a person who used a wheelchair, came into the hospital waiting room and had 3 small service animals with her. They were dogs. One was in her lap, and the other 2 were running around, barking and kind of skidding here and there. So we did say that she needed, if they were service animals, to either get the animals under control or that the hospital was in a permissible position to actually remove the animals from the location. Another case presented a little bit of a different issue. Was a doctor's office. They had a single treatment/examination room, And the doctor was concerned that if the patient, who was a person with a disability with a service animal, brought her dog in, that given the physical examination that would take place, the physical touching of the patient, of the handler, as well as potentially any expressions of discomfort by the handler, the doctor was concerned that the animal would perceive this as an aggression towards the handler and might become aggressive towards the doctor. It seems like, well, okay, that could happen, but again, we really want to look at what is the evidence in the given case and not just sort of unfounded assumptions about what might happen. And in that case, we actually did not find any evidence of aggression by the animal, so we did find that the exclusion was inappropriate.
And the whole issue of control and behavior, to the occasional nature of something. If a dog yips, it doesn't automatically mean, oh, that dog's out of control and now we can make them leave. That would be problematic if a covered entity did that. I mean, this really is, first of all, the individual has to be given the chance, if, let's say that if it is more barking, you have to be given the chance to correct that behavior. So, or, if you're in an environment where you have a bunch of little kids and they're pulling the tail of the dog, that dog is going to yip. And so, again, you have to look at what does, out of control really mean.
Right, and the person, as we talked about earlier, also has the right to turn to family members or companions to take control of the animal and maintain that while the person may be otherwise not able to do it personally. Isolation, separation, another important issue. As a general rule, the person with a disability should not be separated from their service animal, and the person with a disability and their service animal should not be separated from other individuals receiving comparable services in comparable circumstances. We did have a case involving what was essentially a business meeting between the person with a disability and their service animal, and the person who was on the staff was afraid of dogs and so wanted the animal omitted completely from the meeting area. The person with disability appropriately said no, and as a compromise, they agreed to meet in a very large room with the individual and her service animal at one end and the staff person at the other end. And we did also find concerns about that. There are alternatives. They could have had a different staff person meet with the individual. They could have ensured that the animal was sufficiently under control to assuage any concerns that the staff person may have had, but fear of animals is generally not going to be a permissible reason to treat the person with a disability differently. Also wanted to mention another case, and this was interesting, involving a dialysis center. A person with a disability came to the dialysis center with her service animal, and they said that unless she had documentation demonstrating a need for having the service animal at the facility, in light of the health activities that the person would be going through, that they would not permit the service animal. So they locked her service animal in a bathroom for 3.5 hours, and they took responsibility for pushing the woman's wheelchair and for situating her for treatment. Again, this is impermissible. Just because staff can do functions for a person with a disability, and maybe they can, maybe they can't, but the person has a right to function independently. They have a right to the service animal unless some of the exceptions that we've talked about are met. So either the animal is out of control, the animal is not housebroken, or there is an actual risk of significant risk of to the health or safety of other persons in the environment. So. Yeah.
And it's really important that a service animal not be separated from the handler for any other number of reasons. This is a relationship between a human being and an animal on which he or she relies to function independently. And the longer apart, first of all, the animal may have significant anxiety and separation anxiety. And it can also deteriorate this relationship that has, over the years, really been worked to develop. And it just doesn't end well. in almost all circumstances when there's a separation.
Okay, we want to spend some time on this slide. We're trying to put together some of the legal standards and the medical guidance that we've talked about and make some very general, I guess, advice as to what kinds of areas in healthcare facilities animals generally may be able to go and or generally not be able to go. And you know how we like a little wiggle room in the government. All of these things really depend on the circumstances. So healthcare facilities are different, service animals are different from one to another. But if you were to look at the legal standards and the medical guidance together, this is some sort of general parameters for where we think generally service animals could or couldn't go. I wanted to talk about a couple of these in particular. Emergency rooms, for example, we do get a lot of cases involving emergency rooms. And our standard, again, would generally be, unless the animal presents a risk of health, to the health or safety of others that cannot be mitigated or eliminated by taking reasonable measures, that the animal should be allowed access. And again, all of these judgments need to be individualized. They need to be based on reasonable judgment, on medical knowledge, and not on unsubstantiated concerns. So in an emergency room, for example, if you look at the type of persons that typically present to an emergency room, they're persons that may have open wounds, they may be bleeding, they may have undiagnosed transmissible conditions, they may not look necessarily clean, they may have parasites, animals as well. And if the risk of transmission from the animal is less than it is from persons, it would seem if the person is able to be in these different types of conditions in an emergency room, then the animal should not really pose any greater risk. So we would, and haven't really found any circumstances where an animal would be justifiably excluded from an emergency room. Also wanted to talk about treatment rooms. We see a lot of cases involving doctors' offices, and I'll just mention one. We had a case involving a doctor that had one treatment examination room. He was concerned about allergies, he was concerned about germs, he was concerned about exacerbating the conditions of other patients who may use the same room. He said that he performed a whole range of procedures in this room, including, and I will mention some of them, skin biopsies, incision and drainage of wound abscesses, minor surgical procedures, nebulizer treatments for asthmatic patients, and administration of vaccinations. And again, if you look back to the CDC guidelines, they teach us that if you have a room where there aren't infection control measures in place, such as gowns or masks or gloves, if you don't have special ventilation requirements in place, and this room did not have any of those features, then generally the service animal should be permitted access as well as a person. So again, we found exclusion of the service animal from this treatment room to be impermissible. And let me just mention allergy clinics. It might be surprisingly on the generally yes list. It's because even if an animal can't have complete access to an allergy clinic because of certain circumstances, it is generally possible to make some sort of accommodation so that the person with a disability that uses a service animal also has access. But let me mention this one case. We had an allergy clinic that started out with a prohibition of service animals in total, and then they agreed to allow this particular woman to come with her service animal 2 days a week, to use a separate entrance, and to wait in an area that did not have as much of a patient population as their general waiting room. Sounds like it might be reasonable, but here was our concern. This particular provider singled out service animals and the allergens that animals might present with. It did not take any steps to limit the introduction of allergens that might, or agents that might trigger a person's allergies, such as colognes or perfumes or deodorant. It did not seem to regulate things such as the fiber in the carpets or the types of cleaning solvents that may be used in the doctor's office. And instead, they allowed patients and visitors to come and go really unrestricted. They only limited the allergens that the service animal presented. So what we required as a settlement was for the doctor's office to do a self-evaluation. They needed to identify the types of restrictions that would be put in place based on evidence from that self-evaluation. They needed to identify ways that they could take to try to reduce exposure of persons. They were to let individuals coming into the allergy clinic give them advice, recommendations on steps that they could take to reduce their exposure to allergens. They needed to train staff on what the appropriate process was, and also to treat people fairly. So if there is a legitimate concern about risk to other individuals, there are steps that providers can take. But again, you want to have people treated equally and fairly, and for these restrictions to be really based on evidence and not supposition.
And let me add too that we have had similar kinds of complaints that have been filed with us, and it's really, really important that yes, there are some legitimate reasons where a service animal could be excluded from an area or certain times of day, but it really has to be based in reality, and it really has to be based in what other practices, because on its face things can sound very reasonable, but when you see that the case that Eileen was just talking about, when there are no other steps taken to limit whatever bad effect some kind of an allergen would have, they simply didn't do it. So you really have to look at things in practice. I mean, how do they really screen and protect patients with all different kinds of allergies, not just those with allergies to dog dander or dog saliva?
Yeah, and on the generally no list, I just wanted to mention again one instance that we saw involving an operating room, and these are generally areas where, as you can see, that they would have infection control measures in place, which is why they're on the list of the areas that service animals generally could not access. But we did have one involving an operating room where the individual with a disability and the service animal, he wanted to be able to bring his service animal into the room. He was getting a non-invasive procedure done to him, and the facility took the position that this is an operating room that is also used for invasive procedures, and in those circumstances it is a sterile environment. But at the time that it was being used by this particular individual, it was not a sterile environment. So as you can imagine, we do have some concerns about if this environment is not sterile and the person is coming in using their street clothes and the physician is operating using street clothes, what is the concern about having the service animal on those circumstances? So that's why it's important to look at the use of the particular area in the facility. Now I think we want to take some time before we use up all of our time to go over some of the questions and answers that we did receive. We did try to answer some of them as we were going through the presentation, but we also have a couple that we'd like to share with you. So I'm going to share the first of these 4 questions. It's a question for Sally, and the question is, when an individual with a disability becomes a patient in a hospital, does the person have a right to keep his or her service animal with them? Does it make a difference if the individual has arranged for family or friends to come in and care for the animal during their stay?
And I think this is a real common question that we get at DOJ, and I know you folks get this a lot. I think the first is a resounding, the first part of the question, if you're an inpatient in a hospital and use a service animal, do you have a right to have that service animal with you? And the answer is a resounding yes. All capital letters, Y-E-S. And then the follow-up question was, does it make a difference if the individual has arranged for somebody else to, remember we talked about earlier, for the care and supervision of that animal? And I think they're almost 2 separate questions. The first is, do you have a right to have that animal in with you? And the answer is yes. And then you go to the care or supervision of the animal, which never is the hospital's responsibility. So yes, if you have arranged for a buddy to come, a family member, a volunteer that you were able to talk to, the key is that it really doesn't matter who takes care of that service animal, as long as it's not the hospital itself. They are not required to do it. So I think that it's almost 2 separate questions. One is, yes, you have a right if you use a service animal because of a disability. And 2, the hospital doesn't ever have an obligation. They're not going to have that obligation to feed, water, exercise, groom, take out to a grassy area. So I think, yes, you have a right, and you also have an obligation to ensure that the health, the supervision and care of that animal is taken care of by someone other than the entity.
And here is a second question. Does a patient with a disability who uses a service animal have to be put in and pay for a private room in a hospital? If the patient with a disability is assigned to a non-private room, such as 2 or 4 beds, does the patient have to ask permission from their roommates to have his or her service animal stay with them?
This is a really good question. Mm-hmm. I like this question. The first part of the question is, if you have a service animal and you are going to be admitted to a hospital, must you be limited in your choice of rooms to a private room? And I think that the answer is generally it's not. Well, first of all, it would be no. But then I'll say it's generally no. It depends on the kinds of hospital, and just sort of like the allergy clinic that Eileen spoke of earlier. So that's a no. You can't be required to do that as a condition of being admitted to a hospital. Then the other question comes, what if you're in a non-private room? What happens with the other patients? And I think the first thing is that you as a patient wouldn't be required to go around and be asking permission of other patients if it really isn't your responsibility. The responsibility is for the hospital to inpatient you, I think I've developed a new word, to a room that would be appropriate for your healthcare needs, just like they would do any other. And then beyond that, they have a requirement to modify their policies if it's necessary to allow you to have that equal access. Now, it's really going to depend on the roommates and who are the roommates? Are roommates, do any of them have a disability? And say that they have a really significant allergy to dog dander or to dogs. And then what do you do? And then I think the healthcare provider has the obligation to see what other opportunities they have to be able to meet both parties' needs. And it may be, you swap people around, put them in a different room, but under the same circumstances. I think that you have to be really, really careful to make an assumption that because you use a service animal, you don't have the same choices. I'm the queen of bad analogies, but let me try one. It would be like if you went to a hotel, and if they said, we are glad to have you here with a service animal, but there's only one kind of room that we will allow you to use. It really isn't a whole lot different if you're talking the healthcare context. Now, the other question is the generally portion of this. And say that there's a hospital that is chock-a-block full. People are in the hallways. There aren't any beds available because of the flu. And there may not be any other opportunity or other alternatives. But they would still need to work with that to see what they can do to make sure that you have the same level of access as somebody else would have. But again, it's not a responsibility of the patient to ask somebody if it's all right, if the hospital puts them in their room. Remember, the hospital is the one who is controlling this. And the hospital has to do whatever they can to modify their policies, to maybe shuffle people around if it's necessary. But remember, Eileen talked about a little while ago, and we both talked about that any decision, this borders on the exclusion rule that we talked about. And any decision that, somebody who uses a service animal can't be in a room with other people has to be made on current, objective medical information. It can't be, well, down the road somebody might have some event. But again, it's really going to also depend, without going too much in the weeds, it's also going to depend on what services is that hospital offering. And if, for instance, it's a psych unit, and there are a couple of rooms set aside, they're double rooms, you know, semi-private rooms, but they are set aside for treatment of people who have incredible phobias about dogs.
And we're going to talk about this too.
We are. So, with all of that, I'm going to punt. I'm going to move forward. And I think it's your turn.
It is my turn. It's your turn to ask the question.
I will ask the question. I'll use my best Alex Trebek voice.
Oh, okay.
Okay, Eileen, do patients with disabilities have a right to have their service animal with them if they are in a locked ward in a psychiatric unit? And the second part of this question is, does the staff have to allow family or friends to care for the service animal?
And here's the trick answer. It depends. So we want to go back to those questions that we've been asking ourselves to see where service animals can and can't go. So let's look at the population. And this is a little bit different because you're probably not looking at a population that is particularly susceptible to infection, that has compromised health conditions. Now, they may, because we don't know necessarily what the population in the psych ward is, but at least we know that there are people that are in there for mental health conditions. Now, Sally did bring up the circumstance that you could have somebody who is in a psych unit that does have a particularly strong phobia of dogs, and that may even constitute a disability, perhaps, depending on the phobia. So that is something that they would need to take into account. But if you look at the types of issues that we would be facing in a healthcare facility generally, first, we probably are not looking at a significant risk of infection of some condition from the service animal to a person, so that probably would not be a basis for excluding the service animal from a locked unit on a psych ward. Second, you want to look at the type of program that the unit has. They probably have a program that may include certain group activities, probably some therapy, maybe group therapy. They may even go off-site for some activities. These are generally types of activities that a well-behaved service animal should be able to participate in without disrupting the program. Again, it's going to depend on the particular program that a facility has, and assuming that we have a well-behaved and a clean service animal. But I would say that generally we would think that unless there's some particular circumstance, and again, this is going to depend on the particular program, but that probably a service animal should be permitted access to a locked unit on a psych facility. Now, the other question is interesting, and this is a little bit different than perhaps the healthcare facilities that we've been talking about, where you actually have a locked unit, and whether family members or friends can come and take care of the animal, take the animal out of the unit and bring it back. So I think one of the things that we would like to look at, and again, we want to generally start with saying that yes, the person with a disability can turn to family and friends to help care for the animal. One of the things we want to look at, though, is maybe there are parts of the programs or parts of the activities that are going on at different hours of the day. They may have meetings that take place at nighttime, so there may be a need on the part of the person with a disability to look at the scheduling issue. But that should be something that folks should be able to accommodate. So they don't want to disrupt the program and perhaps have somebody from the outside coming in when maybe patients are having a group discussion, or they're doing a touch base with staff in the unit in the evening or in the early hours of the morning. So that may be one issue to think about. Another may be we want to make sure that the security is not compromised by having somebody come and go, but you would think that the staff in the facility, in the same way they may let staff come and go from the locked unit, that they should be able to accommodate persons from the individual with a disability's family that may need to come and go at different times. I think just because we don't have visiting hours that may mesh up with the animal's needs should not be a bar, because we would expect hospitals and other types of hospitals to also allow persons to come and take care of the service animal, even though it may not be during recognized visiting hours. So I think we would generally say yes, the service animal should be given access, and the service animal's the family of the individual with a disability should be able to work out some kind of arrangement with the facility that would allow them to take care of the animal without changing the program. And again, you would have to look at the particular program. I know we say this, but it's really because it does make a difference what the circumstances of the case are, but we want to at least be able to give some general guidelines here and for people to kind of know the types of issues that they would need to think about when they're in these circumstances.
So saying it depends is a legitimate thing to say for us. I know you guys are all going, oh, they say it depends, but everything is so fact specific, right?
It is, but again, you know, I think we do want to leave at least with the idea that for these situations that we've talked about, we don't see in the question that's posed any reason for why a service animal should be denied access. So unless you find something out, you know, in the circumstances that lends one to think differently, you know, from what we know, it sounds like it should be something that's possible to arrange.
Right. And I'm going to ask you your second question, and I think this one really involves a really good example of the human cost of discrimination. So the question is, does this law apply to facilities or area within hospitals that house family members of patients in the hospital overnight so that they can be closer to their hospitalized family member? And it can also be an off-site place where folks can go and stay. May they deny access to family members who use service animals?
And I think the first answer is a very clear yes. The law does apply to these areas within hospitals because the law applies to all of the operations of the hospital, and we talked about all of those areas early on. And second, the law also does apply to these types of facilities. The ADA clearly applies to places of public accommodation. Whether Section 504 would apply would depend on whether the entity gets federal funding, and it may or may not, but the ADA almost certainly would apply. So these types of facilities are covered. The question about whether they may deny access to a person with a disability to a family member who uses a service animal, I would say is really a no. I don't know if we even need to put a generally in there, although one hesitates not to, but I think, you know, these facilities are accepting sort of average members of the population. We're not looking at the types of health conditions that individuals may have that make us more cautious about looking at access of service animals to burn units or hospital operating rooms or to certain care areas in a hospital. You're really looking at what's more like a hotel or you know, just a housing facility. So we would say yes, the person should be able to go there with their service animal, unless there is some particular reason why a particular service animal is inappropriate for inclusion. And I think we wanted to add this particular example to just give you a little bit of background about it. It was posed by an individual who was going to one of these facilities. Her mother had been staying in a hospital and was in very poor health. She went to one of these facilities with her service animal and was denied access, as a result of which she went home, which was a fairly long drive. And when she did receive a call from a family member to come to the hospital quickly, she was unable to get back to the hospital in time to say goodbye to her mother. And so, as Sally said, this is, you know, for me, it's just such a compelling example of why these laws are so critical, so necessary, and so important. People should not be put in a situation where they lose an opportunity such as this. And, you know, the law is here to provide for this. This is why we have these laws, why we're here, why we want to be able to talk with you to inform recipients. And there are many recipients that want to do the right thing. Many covered entities that you know, don't always know what the law is, but they want to serve people, and that's their business. They want to serve people. But at the same time, it's so important to be educated, whether one is a covered entity or one is a person that uses a service animal, so that you know your rights, so that you can assert your rights, and you know, you can educate others. So, you know, again, it's a really sort of a heart-tugging kind of example, and we've seen cases like this sometimes. But you know, this is why you're there. This is why we're here. So we just need to work together and make sure that we bring society along so that these types of things don't unfortunately happen. So I guess I'll get off my little soapbox here. And
but it's true. And one thing is that I think because this is a federal regulation. These are federal regulations, and I think they see it as the federal government, and people don't necessarily see how it affects the person, who may be their relative or, another human being. And very often it's seen in regulatory language and cold and stark and prescriptive. But these human stories are very understandable. And I think that they go a long way to help people understand why it's so important that equality and the same opportunity, and that the fundamental principles of the ADA and the Rehabilitation Act are so critically important. It isn't just a federal law, although it needs that to ensure it, but I think these stories, and especially this one, this got to me as well. It's really important that people understand what it really means if you're denied access.
And on that note, I am afraid we may have overstayed our time, but we just want to go quickly through these last 3 slides, really to tell people about opportunities that you can take if you think that you have been discriminated against. Most covered entities are required to have either an ADA or Section 504 coordinator that should be able to answer questions for you. That information should be posted. Most facilities are required to have a grievance procedure so that you can file an internal complaint. You can file a discrimination complaint with either of our agencies. Sally's office enforces Titles 2 and 3 of DA, although the healthcare facilities are delegated to HHS for enforcement, and we both enforce Section 504. So you can file with either agencies. The same standards apply, and we will do an investigation where we have jurisdiction, or you can also file a private lawsuit. And I'll leave the rest to you.
All right. And that's pretty much it for that slide. If you don't, anytime you're not sure, it never hurts to file with both agencies. Never hurts. Be aware of any filing deadlines. So for Title II, for the ADA, you're really looking at 180 days from the last date of known discrimination. So you don't want to blow that, because then you will have essentially lost your right to file.
Yeah, just very quickly, we don't really need to spend any time on it. We do investigate discrimination complaints. We have down there the website for the agency, and you can sort of peruse your way around the website, and also 2 telephone contact numbers, and you actually will get a person at the 1-800 number.
And now we're on the DOJ resource slide, and exactly what Eileen said. We do investigations and we provide technical assistance. If you have questions that you think of after this, or you would like to download information, go to www.ada.gov. That's the department's ADA website. And also feel free to give us a call. You can call our actual ADA specialists who, like Eileen's office, they're actually human beings that answer the phone. At the numbers below on this slide, and please know that all your calls are confidential. So don't be afraid to ask questions. There aren't any stupid ones, except for the ones that you don't ask.
And so thank you to Joan, thank you to all of you for listening in, for hearing us talk. We're very happy to have been here with you. It's an important issue, and we hope you will contact us if you have any questions. We are happy to do any follow-up, and with that, we will sign off. Thank you.